Let's talk about discovery. Discovery is an important part of litigation. It's called discovery because it's that chance where you get to discover information about your opponent's case, and you get to send them different sorts of things to get information from them. And it usually is an important part of the case because it helps you put together your strategy. It helps you fashion what kind of questions to ask the other side's witnesses. It gives you the identity of the other side's witnesses. It tells you where to look for other information. So it's really powerful stuff. The scope of discovery, in other words, what you can ask for, is very broad. Basically, as long as something is relevant, which means it's likely to lead to discoverable information about the topic you're addressing, and it's not privileged, you can ask for it. And in cases where people seek to embarrass or otherwise burden people with discovery requests, you can seek the court's intervention, usually by what we call a motion for a protective order. And a protective order would simply do just that. It would say you can't ask any questions about this, or you can't ask any questions about that. That sort of thing. So that would be how those things would play out. Discovery is, it's the same devices, and the discovery devices, which I would suggest that you know, would be interrogatories, which are written questions. There would be requests for production of documents, which speaks for itself. You want some documents, you ask for them, the other side's got to give them to you. There are depositions, which are basically statements that are taken from a live witness under oath. There are requests for admissions. An admission is an acknowledgement that something's true. So that if I were to say I was driving too fast on the highway, that would be an admission against my own interest. That is, that it's bad for me. So you'll ask people to admit things that aren't so good for them. You might say, admit or deny that you were traveling at 80 miles an hour at the time of the crash. And people have to respond to those sorts of things. There are a couple other devices which are somewhat kind of common, but kind of commonsensical as well. One is a request for medical examination. In personal injury cases where someone is alleging that they've been injured, expect that the other side will send you to their own doctor to have their own separate evaluation. And a running joke in personal injury law is that a defense doctor, in other words, a doctor that's trying to say the person isn't injured, would usually look at a dead person and say, oh, they could do part-time work. And the reverse is true with plaintiff's doctors. If someone has a hangnail, they'll say, well, that person won't be able to work for 5 years. So it's oftentimes a clash of those experts. Otherwise, the devices for discovery are pretty much the same both in state court and in federal court. But there is one very large difference between the two discovery systems. The discovery system in the federal court has an odd feature to it that the Pennsylvania courts do not have. In federal court, once you answer the complaint, then you have a limited period of time to voluntarily disclose information about your own case. So it's called a voluntary disclosure requirement. And basically you have to give a fair amount of information to the other side. You have to give the names and addresses of all the witnesses. You have to give a summary of your claim. You have to give insurance information. There's a number of features. They're all in the federal court rules, but they require the party to produce those things without even being asked. So in federal court, if you're the plaintiff, when the other side's finished filing their answer, you need to send them information about your case without being asked. Again, a broad set of information. They'll want to know a little bit about your injuries and your damages. So that's quite a different circumstance. In state court, if someone doesn't send you any discovery requests, you're not going to provide them information, in my experience. So that's a little bit of a difference between the two. It's also the scope that we just talked about. So what I was going to try and do with this is just kind of stick to the early parts of discovery for now and lead up to some of the later parts. The earliest part in my experience, and I think in most people's experience, is with respect to interrogatories, which are written questions to the other side. And the reason that we usually start off with those in litigation is a fewfold. One, they're cheap. That is, it's only the cost of somebody coming up with a list of questions. To contrast what interrogatories cost compared to depositions is pretty stark. Depositions cost about $4 a page just to start out, not counting copies to other parties. So you can spend $4 a page. The lines are only 25 lines per page, and they're double spaced. Pretty much by the time you introduce yourself and you cough, that's one page. And as they go, they get increasingly, it just builds up page after page after page. It gets very expensive. Depositions are oftentimes one of the largest expenses in litigation. And the idea is that you don't want to conduct a deposition unless you know the information that you want to ask about. If someone is involved in a complicated case and you hold a deposition without knowing what they know and what to ask about, it's going to take an awful lot longer. You're going to waste a lot of time. You're going to waste a lot of questions. So that's why people start with interrogatories. They're cheaper and they start to give you a general picture of what you need to know. Second most, I think, most commonly used device is a request for production of documents. I like it when legal terms ask or called by what their names are. You're requesting the production of documents from people. And you basically follow a form that will show you in the Pennsylvania rules or in the federal rules, depending on the court you're in, and basically attach a list of the documents that you'd like to see, and you give them that list, and you wait for them to be produced. Once you have those and the interrogatories, you really have a pretty, hopefully if you've asked the right questions, have a pretty firm foundation on who the witnesses are, what they know, what their story is going to be, who's got what sort of information. So at that point, you want to probably proceed, and most people do, proceed to depositions. You can send supplemental interrogatories. You can ask for a supplemental request for production of documents. But mostly once people get those back and sort through them, come up with their strategy, that's when people are going to go to a deposition. And that is an important phase in discovery because depositions are very powerful. They're powerful in the sense that, first of all, they're live. So it's really the very first time usually that each of the parties are together, where the defense witnesses face the plaintiff's attorney and the defense's attorney faces the plaintiff's witnesses, and each get to ask them questions. Those questions are taken down by a certified shorthand reporter and are produced into a booklet form that looks something like this. It's bound. Again, only 25 lines per page, and they very quickly turn into a lot of pages. But you get to ask people in live time. In many personal injury cases, insurance companies will not permit anyone to settle a case until they have had their attorneys take a deposition of the victim, the live person. There's a few reasons for that. One of them is that you just want to gauge, how is this person? How do you think they'd stand up in a court? Do you think a jury would like them? Are they sympathetic? Sometimes you come away thinking like, they don't seem very likable. Maybe a jury wouldn't believe them. Maybe a jury wouldn't like them. So you really try and get a sense of the person. It really gives you a sense of what that person might be like at trial. So you really do follow a lot of the cues that come to you from body language, that come to you from people's styles of answering questions. And it's oftentimes kind of exciting. As a paralegal, you will often prepare people for depositions. I used to prepare people, I used to kind of spend a lot of time with folks. I'd usually meet with them usually maybe twice. And basically what you would do is go over the interrogatories, go over the questions that they've answered already, go over the documents that have been provided, and make sure that your client understands what the questions will be and what the answers were that they gave. One of the things I would always tell people is that this is a deposition. It's very important. What can be done with this deposition is it can be read into the court record at trial, or you can be questioned about it. So you want to take your time. You want to listen to the questions. If you don't understand it, you want to make sure you have people explain it to you so that you do understand it, and then answer it and never guess about the answers. The deposition is really a crucial phase, and most people would say that it's really the most important part of a discovery process. You can only send interrogatories to people that are a party to the litigation. So Mr. Butler could only send interrogatories to any of the defendants in the case. Can't send it to anyone else. With respect to depositions, you can have people submit to depositions that are not parties to the case, but the only way you're going to be able to get them to appear usually is to send them a subpoena. So that's why a subpoena is really important. Subpoenas are used for people that are not parties to the litigation. So from that standpoint, the subpoena becomes important too for non-parties. You can make folks show up and have to submit to a deposition. With respect to depositions, you'll see in this week's sessions that we have excerpts of a lot of very interesting depositions. And I'll tell you some more stories in a bit about depositions that we've been involved in over the years. I think you'll get a kick out of some of it. All right, that's all I wanted to do. I wanted to give you a little introduction to depositions. So my work here is done, and thanks for listening, everybody.